Okay, so this is Senate Health and Welfare. We're back. And we're looking at two bills with the sponsor, Senator Ruth Party. And we're going to look at 210 first. And then after that, if you could go to 112, that would be great.
Perfect. Thank you, Madam Chair. Thank you, committee, for having me. I'm Senator Ruth Hardy from the Addison District, and I'm here to talk about two bills, S210, which is a bill about autopsy reports, and it would enable the probate division of the Superior Court to rule on a petition for access to an autopsy report. I introduced this bill after talking with a constituent who I definitely think you should hear from if you move forward with this bill, which I hope you do. And she can tell you her story as much as she feels comfortable. But she had some very tragic situations happen. A situation happened in her family that resulted in the death of her daughter, her adult daughter. She was first in line to receive the autopsy report from her daughter's death. And then previously sort of the father of the children of her daughter, who had been out of the picture, came back into the picture, proved his paternity. He hadn't been in the lives of the children. He proved his paternity, and then he moved up the line to get the autopsy reports and wouldn't let the mother of the daughter of the woman who died get the autopsy report. There's a hierarchy, and Katie can explain this much better than me, but there's a hierarchy of who gets autopsy reports. They are protected by federal HIPAA laws, the health privacy laws. And so she was not able to receive the autopsy report, and obviously a grieving mother, and it was very traumatic for her. And there are a lot of other factors, but it's not my story to tell, so I don't want to divulge anything.
But that's helpful.
But that's the sort of general background. She was not able to get access to the autopsy report, and the Department of Health, which is the department that oversees the medical examiner and the provision of autopsy reports, couldn't give it to her. And there was obviously tension in the family, and she wasn't able to access it. So this wouldn't automatically give autopsy reports out to people, but it would create a process by which someone could petition the probate court to get an autopsy report. And Katie worked really hard with the Department of Health to make sure this is compliant with HIPAA and works with their regulations. Obviously, you should hear from them to make sure that they agree with that. But that was the goal, is to make sure it's compliant with the federal HIPAA regulations and also the process, but also just gives Vermonters an access to an autopsy report if they're in an unfortunate and sad situation like my constituent is in. So it would be a petition to the court, and the court could deny it. So if someone was trying to get access to an autopsy report for various reasons or inappropriate reasons, the court could say no. But this would give people who are trying for legitimate reasons an avenue. So that is S210.
Good. I mean, it's that helpful. That gives us the reason. One of the things that we're trying to do is sort out for the bills is why are they being introduced?
Yeah, absolutely. And that without the story, it doesn't necessarily make sense.
And if you don't mind, contact your constituent and see if she is available or would like to testify.
She absolutely would like to testify, so I will connect her to your committee assistant and you can, she would love to come in. Thank you very much. So S112, another bill that unfortunately deals with death.
We'll get Tucker in another day.
Yeah, I guess it was an unintentional theme. But this one I actually introduced last year, and this has to do with the gender identity of an individual on their death certificate. In Vermont, we've done a lot of work to make sure that all of our official legal documents allow individuals to have their preferred an actual gender identity listed. So for driver's licenses, for birth certificates, for marriage licenses, for all those other legal documents, the one that we haven't dealt with sufficiently is death certificates. And it's hard for somebody to attest to their own gender identity when they're dead.
That's
This
not
is
funny, Senator.
yeah, I mean, it's
But it is ironic and paradoxical.
so trying to figure out how we do this is hard. So this is Tucker and I worked to try to figure this out. And this also came at the request of multiple constituents and Vermonters to make sure that when someone dies, that they're the last document that documents their life and then their death has the gender, their gender identity on it, as they lived and wanted and were in their life. So this would create a process for if somebody's gender identity is incorrect on their death certificate, it could be rectified. And again, it's a process with the Department of Health and creates sort of the rule. It uses appropriate evidence and to ensure that someone's gender identity is verified. So it couldn't just be somebody coming in and saying, no, I want to change the gender identity on somebody else's death certificate. There would be a process for doing so and documents that were accepted as prima facie evidence. And that should be something that Tucker explains to you. There's a reason why that's specifically called out in the bill. And then the other thing that I included is procedures for an individual to file a pre-designation of their gender identity. And this is kind of like when you talk about, you know, when I die, or when I'm sick at the end of my life, these are the things I want to have happen. That there, what if like living wills or and there's another technical term that I'm forgetting, advanced directives. And this could be part of somebody's advanced directive just to make sure that it's clear. And then there's General Assembly intent to make sure that the Department of Health understands what we're trying to do here. And Tucker did work with the department on drafting this bill as well to make sure that it fit with their procedures. There is, I think, a House companion bill that might actually be in GovOps, but I'm not sure what the status is.
Yeah.
Tucker might know because it's
Well, you know,
sort of
I think that might have been introduced last year as well. So I'll connect with the House.
yeah. And if you need witnesses for this, I can certainly help you
That would be good.
identify some witnesses
Yeah,
as well.
Good.
And these also could, I don't know, they're both similar topics. They could be combined if you wanted to, probably, but
Make one bill out of two. We might do that.
yeah. So those are the two bills, and I thank you for considering them and having me in, and I will send you some witness information and let me know, or yes, and let me know if you need anything else.
Okay, questions for Senator Hardy? No, we're good. Brought us some.
Yeah, you're welcome. Thank you for
Good news.
considering it, and
All right.
Good luck.
We'll hear from Katie on 210, and we'll have to talk to her another time when we pick up.
sounds good.
Thank you.
Thank you. What about fishing access?
Awesome. Oh, goody. That's good. Great. Also being able to put your kayak in there. Okay, we are. Oh, your ice boat. Is there not a lot of ice boating this year? Yeah. Oh, the temperatures have been so, you know. So S210,
Yes. Katie McDonough, Legislative Council. So this is amending an existing section that addresses autopsies. There's nothing specific in Vermont statute that says this is who the autopsy report is going to be released to. So instead, the using HIPAA, the health department has relied on, sort of the list, and for probate cases to determine who is the appropriate person to get the autopsy report. So what this language does, A sort of says when an autopsy happens, and I've created a new subsection B here. So the first subdivision B1 is the purpose is to encompass existing law with regard to HIPAA as to who can get the autopsy report. So it's not meant to be a drastic change. It's sort of meant to codify the status quo, which is that the Office of the Chief Medical Examiner shall disclose the decedent's autopsy report to the decedent's personal representative in compliance with HIPAA and its associated regulations, including the court-appointed executor or administrator of the estate.
Not to interrupt the flow here, but
Yeah.
it occurred to me that HIPAA is an acronym.
Oh,
And that perhaps we should
Yeah.
explain what.
Okay.
that is.
So we have it on line 3, Health Insurance Portability and Accountability Act. It governs privacy protections, and it extends for a certain number of years after a person's death. So an autopsy report would be protected health information under HIPAA, which is why receipt of the report is governed under HIPAA. So again, this first subdivision is intended to just refer back to HIPAA and say, you can disclose the autopsy report in compliance with HIPAA. There is language in HIPAA that if a state decides to enact a law that allows a piece of protected health information to be authorized for disclosure using a court process, that is acceptable under HIPAA. So that's what this subsection 2 does, is it says that there is the creation of this court process whereby if the court finds it's appropriate for this protected piece of health information to be shared, it may be. So an individual who is not authorized to receive the autopsy report pursuant to subdivision 1, that person can petition the probate division of the Superior Court for a copy of the report, of the autopsy report. The petition is to contain an affidavit attesting to the petitioner's relationship to the decedent and the reason the petitioner is seeking the autopsy report. The petitioner shall notify the Office of the Chief Medical Examiner within 5 business days after filing that petition with the court. And if the Superior Court finds that the petitioner has demonstrated a legitimate reason for the petitioner to obtain the autopsy report, it shall order the Office of the Chief Medical Examiner to provide a copy to the petitioner. So I'll just bring your attention to the phrase legitimate reason. So that is, it's not a defined term for the court to follow. So the court, it's giving a lot of discretion to the court to determine what is legitimate. So that is sort of a policy decision to have less parameters for the court and kind of keeping it a little bit open. So the court has, like I said, discretion as to what is an appropriate reason and who is an appropriate person to receive the autopsy report.
So you reached out to the DOH on this.
Yes.
Did you reach out to Terry Corsones or Judge Zoning? Oh, that's a good reason to have Terry Corzone come in, isn't it?
Yeah.
That would be good.
Yeah, I think that you're definitely going to want to hear from somebody who can speak towards whether that is a usable standard, the legitimate reason. Oh, there you go.
Good. All right, good. Thank you. That's a good help. And your thoughts about who you should have in would be helpful, but I'm thinking it will go up to the court administrator.
I'm sure you'd like to hear from the health department.
Oh, yeah.
Yeah, and I'm sure you'll need to hear from the courts. Yeah.
Okay.
That's it.
That's it?
We've made it to the end of our time together this morning. You are all very patient.
Questions for Katie? No, but, and I think while you were out, we were just here, all of us thinking about what we need for the child care bill. It's a pretty complex bill, so we'll have to sort through that and see who we need to get.
Okay.
And then Tucker Anderson will have to get in on 112. And see where that goes.
Okay.
All right, thank you. So we are finished for the day and the week, and thank you all. It's been a busy week. We're just getting started. So we are gonna adjourn and go off.